We have a great speaker today. Most of you know him, and if you don't, you're going to be in for a great surprise at his knowledge. Mr. Gov Hutchinson, Senior Counsel with C.A.R, California Association of REALTORS, and a 36-year veteran and pro, all things related to real estate law in California. And with that, I will turn it over. Mr. Gov Hutchinson, thank you so much for being here today, Gov.
All right. Good morning, everybody. Greetings from Los Angeles. Hope it's not as hot there as it is where I am sitting. They're expecting another 103 degrees today, but I think it's hot everywhere. I just want to give you a legal update. As you probably gather when you read the paper, things just keep changing. You realtors have had to be very flexible the last year and a half, and I think you're going to have to continue to be flexible. Things keep changing, but I'll give you the latest, and I'll talk about some COVID stuff, and I'll also talk about stuff that has nothing to do with COVID, because there's other good stuff you should know. Okay, all right. Let's start with the COVID stuff. As you know, the state opened up June 15th, so you didn't have to. Ever since then, as realtors, you don't have to do any of that stuff you were doing for a year and a half. All those PED forms and all that stuff is gone. The only thing you still have to worry about, of course, is wearing the mask. And yes, you're definitely supposed to wear a mask. If you're unvaccinated, anytime you do an open house or a showing or anything like that. Well, what about if you are vaccinated? Well, if you were in LA County or Sacramento or San Mateo or San Francisco or Santa Clara or Yolo or Contra Costa, the rule there is you have to wear, they're back to you have to wear a mask whether you're vaccinated or unvaccinated. But where you are, unless you do some work in LA County, that hasn't happened. So where you are, the basic rule is if you're vaccinated, you don't have to wear a mask. If you're unvaccinated, you're supposed to wear a mask when you go out in public indoor events like a showing, like an open house, like a broker caravan or something like that. Now, of course, having said that, it's up to the seller. I mean, it's their house. A seller can obviously say, in my house, I just want everyone to wear a mask, whether it's a showing or an open house or whatever. I mean, it's their house. They can tell you to take off your shoes too. You know what I mean? It's the seller's house. What about a real estate office? Same general principle. If you're vaccinated, you don't have to wear a mask. If you're unvaccinated, you do. And visitors to the office, clients or vendors or agents from another office, it's the same thing. I mean, if they're vaccinated, they don't have to wear a mask. If they're unvaccinated, they should. You can check their status. You can use the honor system. It's up to you. But of course, a business owner, like a real estate office, you can be stricter than the law. You can say, well, to be safe, I want everyone to wear a mask in this office, regardless of your vaccination status. Just like a seller can be stricter than the law, any business owner or store owner can be stricter than the law. And as you know, the state of California is recommending that everybody wears a mask inside. They're not requiring it. LA County is requiring it, as is Sacramento and many Bay Area counties. So it's hard to keep track of all this stuff. People keep asking me, are those PED forms going to come back? No, none of that's going to happen. It's just the mask wearing at this point. Okay, that's the only sort of change from where we were a year and a half ago. By the way, if you're in an office, believe it or not, I don't know, believe it or not, if you're an business owner, like a real estate broker, what about the people who work in your office? Well, same thing. If they're vaccinated, they don't have to wear a mask. If they're unvaccinated, they should, unless they're alone in a room, right? Or unless they're eating, you can have food and drink in your office. Other than that, unvaccinated people are supposed to be wearing a mask. The only other thing, as a business owner, you are supposed to, if you have any employees, not independent contractors, just employees, you're supposed to keep a record of their vaccination status. There's nothing says you have to give that to anybody. You just have to keep a written record. Okay, I got 3 employees and 2 are vaccinated, 1 isn't, whatever. Independent contractors, you don't have to do that. You just have to have the basic rule. If you're vaccinated, you don't have to wear a mask. If you're unvaccinated, you do, unless you're in LA County, in which case everyone is supposed to wear a mask, regardless of your vaccination status, if you're outside your home, inside somewhere else. Okay, so that's the latest on that. What else is going on? You probably heard that yesterday, the federal government, CDC, extended the nationwide eviction moratorium till October 3rd. We don't really care in California because we've already got the state eviction moratorium that's already going to be in place till September 30th. So maybe if that doesn't get extended at the end of September, we'll have like 3 more days of the federal. But you know, you just have to be flexible. You know, these things just keep changing. They keep getting extended. You can't predict. And once again, if you work in LA County or LA City, they've got their own eviction moratorium that are even stricter than the state, right? Basic thing, let's assume you're not in LA County. What's the basic thing you got to know? Well, basically, like it's been for a long time, if you have a tenant not paying rent because of COVID, you cannot evict them. How do I know they're not paying rent because of COVID? Well, the only way to find out is to try to evict them. You send them the 15-day, not the 3-day, the 15-day pay rent or quit, the COVID version, the PRQTP for transition period. They got 15 days to respond with this declaration of COVID financial distress. If they respond in 15 days, you can't evict them until the end of September. If they don't respond with that form in 15 days, they're just like it used to be. You can evict them right now. You can also evict tenants who are doing something else wrong. Maybe they're not allowing you to show, they're committing a nuisance, they're causing damage, they have subtenants they shouldn't have, they have pets they shouldn't have, they have criminal activity. You can evict them right now. There's no restrictions on that. The only restriction is if they're not paying rent and it's because of COVID and they sign that declaration, then you can't evict them for the next, till at least the end of September. It's stricter in LA if you're there. Well, what's stricter in LA is this. Okay, what if I have a tenant who's not doing anything wrong? They're paying the rent, they're not violating, I just want to kick them out so I can sell the house. Can I do that? Well, not in LA County, you can't. But if you're not in LA County, yes, you can evict them. For 3 reasons, basically. Number 1, the owner wants to move in. Owner, spouse, children, grandchildren. Number 2, you got to take it off the market. You want to take the property completely off the rental market for at least 2 years, you can evict. Or third, for realtors, very important, if you get a buyer who signs an offer that's accepted, as soon as that happens, you can evict the tenant, 60-day notice. You can't evict them before you have the buyer, though. You can't just evict them to get the property ready to sell. You got to wait till you actually have a buyer in contract. Unless you want to use the reason, I'm taking the property off the rental market for 2 years. If you use that reason, yeah, you can kick them out right now. You can sell the property. Of course, the buyer can't rent it out either for a couple of years. Maybe they don't care. You see what I'm saying? If you're in LA County, the only no-fault eviction allowed is owner move-in. So if you're in LA County, you want to sell the house? No, you can't evict. Take it off the rental market? No, you can't do that. LA County, the only no-fault reason you can evict is owner move-in. If you're in LA City, you can't even do that. There is no-fault evictions in LA County. I mean, LA City. So it's very complicated depending on where your property is. That's why we have a legal hotline. If you're in a particular situation, call us up. We'll walk you through it. And we'll make sure you know what form to use, right? Because there's so many different forms. There's special COVID forms when you have to give someone an eviction notice. And get this, even when this is all over, let's say the eviction moratorium ends end of September. So after that, you want to evict someone, right? No restrictions. If you want to, even after September 30th until March of 2022, if you want to evict someone for non-payment of rent, you're going to have to prove that you attempted to get rental assistance, which every landlord should know right now. There's a new law. You are entitled to money. If your tenant owes you back rent for COVID, they haven't been paying because of COVID, there is sufficient money available to you, the landlord, to get your hands on that money. You have to go to the website housingiskey.com, look up your county or your city. It'll show you how to apply. housingiskey.com. And look it up, file an application. You should get the money. The only catch is, unfortunately, is to be eligible to get the money, the income of your tenants who aren't paying you has to be less than 80% of the county median income for a household of that size. Of course, a lot of times if a tenant's not paying you rent because of COVID, that means they probably have a financial hardship. So maybe they are making less than 80%. And by the way, if you want to know what that number is, you can just Google, San Bernardino County, Riverside County, LA County, or just call the hotline. We'll tell you what the number is for a household of 2 or 3 or whatever. But there's rental assistance money there, assuming your tenant doesn't make more than 80% of the median income for a household of their size. What if they do make more than 80%? Well, then all you can do is wait till September, and then you can sue them for the back rent that they owe you, but you won't get the rental assistance. But as I said, even when you can do evictions for non-payment of rent, until March of 2022, you're going to have to prove you actually attempted to get the rental assistance. Of course, I don't know why you wouldn't want to get the rental assistance. Why not, right? Okay, so that's the latest on rentals. And that's the latest on COVID stuff. You just got to stay flexible. These eviction rules hopefully are going to change one of these days. Right now for the showings, it's just the mask thing. That's the only thing you got to worry about is the mask wearing. None of the other things you had to do for those up until June 15, none of those forms, none of those things you have to do. The only thing you have to do is wear the mask. And then offices, as I said, are very similar, other than within an office, unvaccinated people are supposed to wear a mask. Okay, what else is going on? Let's talk about some other stuff. Let's talk about any other new laws or new forms. There's one really significant new law and new form that I just want to go over for a couple minutes because it's kind of confusing, and that's the home fire hardening and defensible space law. And there's also a form for that, the FHDS, fire hardening defensible space. Here's the deal. Here's the way I like to look at it. For the first time in about 15 years, we've actually got a new disclosure law in California. For the last 15 years, if somebody asked me, Gov, what are the mandatory disclosures when I'm selling a house? I would have said there are 5 things you got to do. Number 1, order an NHD report. Number 2, do a TDS if it's residential 1 to 4. Number 3, do a seller property questionnaire if it's residential 1 to 4. Number 4, give them those booklets, the earthquake booklet and the environmental hazard booklet. Although, to tell you the truth, those weren't actually mandatory by law, unless it's the earthquake booklet and it's a pre-1960 house. And then the 5th one is the lead paint form if it's pre-78. So NHD, TDS, seller property questionnaire, booklets, and lead if it's pre-78. Well, now we have 6. We have a 6th disclosure form. This FHDS is a mandatory disclosure form, just like the other 5. The difference between this form and the other forms is it's only required if your listing is in a high or very high fire zone. So now when you take a listing, right away, you got to figure out if you're in a fire zone. There's 4 possibilities. You're either not in a fire zone, you're in a moderate fire zone, you're in a high fire zone, or you're in a very high fire zone. This form is only required in the last 2, high or very high. If you're in a moderate or no zone at all, like I am here in LA, you don't need the form at all. How do I know what type of zone I'm in? You look at your NHD report. Your NHD report has 2 fire check boxes. One of them says very high, one of them says wildland fire area. If neither box is checked, you're not in a fire zone, don't worry about it. If the very high box is checked, you know you're in a very high zone, you got to do the form. And then what if the very high is not checked, but the wildland fire area box is checked? Well, in that case, that means you're either in a moderate or a high fire zone. Well, which one is it? You have to go one step further with your NHD provider and make them tell you, because they can tell you, they will tell you. But it's not right on the face of the NHD report. So let's say I find out I'm in a high or very high fire zone. I pull out the form. It's got 2 parts. The first 3 paragraphs have to do with fire hardening. The 4th paragraph deals with defensible space. The first 3 paragraphs are just a disclosure to the buyer. Nobody has to do anything. The seller just has 6 boxes to check. Do you have a wood roof? Check the box. Do you only have single pane windows? Check the box. And by the way, you only have to check those boxes in paragraph 3 if the house is built before 2010. So if the house is built after 2010, the form is required, but the seller doesn't have to check those boxes in paragraph 3. If the house is built before 2010, the seller does have to check the relevant boxes in paragraph 3. Okay, that's pretty straightforward. The seller doesn't have to fix their house or anything. They just got to check a box if it's got a certain type of roof or windows. Then we have the 4th paragraph that deals with defensible space. And this is slightly more complicated. The whole idea of California law says if you're in a high or very high fire zone, you have to have 100 feet of defensible space. That's not new. You had to have that last year, 2 years ago, a few years ago. That's nothing new. If you live in a fire zone, you need to have defensible space. And if you don't have it, Cal Fire or your fire company could come out to your house today. And if they find out you don't have it, they could fine you. Usually they give you 3 months to fix it or whatever. But that's nothing new. The only new thing is there's now a law that says when you sell a house in a fire zone, high or very high, either the seller or the buyer has to reach out to get documentation that you're in compliance, and you have to reach out to either Cal Fire or your local fire company. So here's the way it works. So first thing you got to figure out is where I'm at, is there a local fire defensible space ordinance that requires me to do something at point of sale? Where you guys are, I don't think there are any. The only ones we found that actually mandate on a local level that you do something are in Northern California. Now, some places like Big Bear, they got these every 6 months, they have an inspection. But it's not triggered by a sale, it's just triggered by every 6 months they come out and inspect. So there's no local laws where you are that require you to do something at point of sale, which means on that form, you're not going to check for B 3 or 4. So in your sales, it's going to come down to 2 things. You're going to ask your seller, hey, seller, has any CAL FIRE or local fire company been out to your property in the last 6 months to see if you're in compliance with defensible space? Seller says, yeah, they were here 3 months ago. Did you pass? Yeah, I did. Great. Did they give you something in writing saying you passed? Yeah, they did. Great. Give it to the buyer. We're done. What if the seller says, no, as a matter of fact, nobody came out to my house in the last 6 months? If that's the case, listing agent in paragraph 4 of this form, 4B, you're not going to check any of the boxes. It's going to default to paragraph 4B1, which says the buyer agrees within a year after close, they're going to go out and call up, they're going to make a good faith effort to get documentation that they're in compliance with defensible space. Well, who are they going to call? Well, if they're in a state fire responsibility area, they're going to call CAL FIRE. If they're in a local, they're going to call their local fire company. Then the buyer's going to ask you, how do I know which one I'm in? How do I know who to call? It's very easy. Call your local CAL FIRE office and say, hey, there's this new law. I just bought a house. I'm supposed to ask you to come out and inspect. CAL FIRE knows about this law. They're ready for your call. If you're in a CAL FIRE area, they'll come out and do it. Although otherwise, CAL FIRE is going to say, well, thanks for calling, but your house is not in our jurisdiction. Then what do you do, buyer? You call up your local fire company. Say, hey, I just bought a house. I'm supposed to ask you to come out to check it out in the next year after buying it. Some of these local companies we've determined, they're going to say, okay, sure, we'll do that. And a lot of them are saying, no, we don't do that. We don't come out and inspect upon request. Maybe we respond to complaints. Maybe we do random audits, but we just don't do it. We don't have the resources just to come out just because you ask us to. If that's the case, buyer, you just write, okay, I just talked to John Smith at the local fire company. He said they don't come out. I'm done. That's all you got to do. So listing agent, your job really is just to ask the seller the question. Have you had an inspection in the last 6 months? Do you have the paperwork? If so, I'm going to check the box in 4B2. We're going to give it to the buyer. We're done. On the other hand, if the seller tells you they have not done this, had this inspection the last 6 months, you're not going to check any of those boxes on the form. The form's going to go to the buyer, and then the buyer is going to sign it. And then that means the buyer has agreed that within a year after close, they're going to go do this. Is it your job as the agent to help the buyer? If you're the listing agent, you're done. If you're the buyer's agent, is your job to help the buyer with this process? No. But obviously, anytime your buyer signs something, it's your job to sort of explain what they signed. So you're going to say, see what the form says here? It says you got a year to do this. Then the buyer may say, well, can I take care of this before close? And the answer is not really, because remember the purchase contract says buyers cannot have any government inspections in escrow without the seller's express permission. So the seller may say, no, wait till after close, then deal with it. You see what I'm saying? So we got a Q&A that covers this. I know it's kind of complicated, but I try to simplify it for as much as possible. You know what the one confusing thing is? CAL FIRE says on their website that every time you sell a house in a high or very high fire zone, the seller is supposed to get an inspection. That is false. CAL FIRE is wrong. We've been talking to CAL FIRE to try to get them to change their website. But I don't care what they say. I'm telling you, you can, and this is being recorded, you can quote me, you don't have to do that. It's the buyer's responsibility. It's not the seller's. It's only the seller's responsibility if you lived in certain places where there's a local point of sale defensible space law that requires the seller to do something. And there are none of those that we've just, if you hear about one, tell me. Maybe some town, some city you're familiar with has such a thing. But we haven't heard of any in Southern California at this point. Okay. All right. Are there any other new things I need to know? Well, the only other new form that came out recently is something called transfer of listing, TOL. This is an optional form. I don't know if you've ever had a listing and you want to give it to somebody else for whatever reason, or maybe one of your agents has a listing and they want to move offices and they want to take the listing with them. You don't, if you're the broker, you don't have to let them take it. It's your listing. But if you're willing to let them take it, we now have a nice new form, the TOL, which is a good way to document the transfer. It takes care of release of liability, takes care of agency, takes care of transferring files. It takes care of any compensation that's going to be paid to transfer the listing. So it's there if you need it, right? And those are really the only two new forms: the Fair Housing Defensible Space, FHDS, which is required every time you sell a house in a high or very high. By the way, if it's exempt from the TDS, it's exempt. You don't have to do it. Like if it's a probate sale, REO sale, bankruptcy sale, sale by a trust, if the trustee was never on title, then you don't have to do this form, even though you're in a high or a very high. If a TDS is required, the fire hardening defensible space is also required if it's in a high or very high fire zone. By the way, I forgot to mention one thing on that. What if you give the form to the buyer and the buyer says, what's this form? Oh, this form, you're promising to go get an inspection within a year. Buyer says, I don't want to do that. I'm not going to sign this form. What do you do if you're the seller and you give this buyer this fire hardening defensible space and they refuse to sign it? Well, you know what the purchase contract says? It says buyers have 17 days to sign and return all disclosures. What if they don't do that? Seller, you can give them a notice to buyer to perform and then you can cancel them. If I'm a seller and I fill out this form and the buyer refuses to sign it, what's the safe thing to do? In my opinion, the safe thing to do is don't sell to that buyer. Because it's not clear from the law that if the buyer refuses to do it, then it might fall back on the seller. We've been trying to get an answer. Is that really the answer? And CAL FIRE won't give us an answer yet. So the conservative advice, if I'm a seller selling a house in a high or very high fire zone, and the buyer refuses to sign it, saying, I don't want to do this 1 year thing, is okay, I'll sell to somebody else who's willing to sign it. Because I don't want it to fall back on me, the seller, that I sold a house without getting the buyer to promise to go out and do this to get the documentation of compliance. Gene and Olga are asking about the AVID. Are you asking me, is that a mandatory disclosure? I'm saying that's part of the TDS, right? That's part of the TDS. So in my group, by the way, did you know the listing agent is required? The listing agent's AVID is required, but the buyer's agent is not. I mean, when the TDS is filled out by the listing agent and they attach their AVID, by the seller, and they attach the listing agent's AVID, you give it to the buyer, it's done. The buyer's agent is supposed to do their own visual inspection. They're supposed to do an AVID, but if they don't, the seller and listing agent have still done their job. The TDS is considered complete. As soon as the buyer's agent receives it, the buyer has 5 days to change their mind. After that, they got to go through with it. It doesn't matter whether their agent has done their AVID or not. It's the listing agent's AVID that's crucial to the buyer's right of rescission. Brenna Walsh, very good question. No, this does not apply to vacant land. The fair housing defensible space is only required on property improved with 1 to 4 units, including condos and mobile homes. Of course, if it's a condo or a mobile home, the individual owner can't really take care of the defensible space, right? Because they don't control it. So you're selling a condo or a mobile home, the seller still has to fill out the form, which is kind of crazy because they're not really it's the mobile home park or it's the HOA that's actually responsible for doing it. All you can do is fill out the form to the best of your ability. Vicky, you're right. When I say the avid is required, I'm assuming that the seller on the TDS checked the box that says, see attached avid. Most people do that. If they don't do that, then you're right. The avid is not part of the TDS at all. And it doesn't trigger any 5-day right of rescission. My experience is most listing agents do fill out an avid. All they really have to do is a visual inspection and disclose in writing what they see, okay? All right, so that takes care of this COVID stuff, that takes care of the eviction stuff, that takes care of the important new disclosure law, that takes care of the only other new form that came out, the transfer of listing. Another thing, remember Prop 19 is in effect now. Remember what that means. That means if you are over 55 or severely disabled or the victim of a wildfire, you can take your house and sell it and buy another house anywhere in California and transfer your property tax that you're paying on the old house to the new house. And you can do it 3 times in your life, not just once. You don't have to stay in the same county. You don't have to stay in Southern California. You can sell and buy another one. You got 2 years between. You can actually buy the new one first and sell the existing one later. You can sell the existing one first before, as long as you get 2 years between transactions to do this. And the good news about Prop 19 is you can transfer your property tax even if the new house costs more than the old house. Under the old law, you could only do this if the new house was cheaper than the old house. Now, even if it's more, I'll give you an example. Let's say you bought a house a long time ago, $200,000. It's now worth $800,000. You want to sell that house and buy a new one for $900,000. You're over 55 or disabled. What is your property tax going to be on this new $900,000 house? Well, it's going to be whatever the low property tax you were paying on the first $200,000 house. And then since the new one cost $100,000 more than the old one, you're going to have to add $100,000 to that. So your property tax base on this new $900,000 house is only going to be $300,000. And if the new house costs less than the old house, then your property tax basis on the new one is going to be just that same exact low property tax basis on your $200,000 house that you've been paying all along. So if the idea of this is some people over 55, they're hesitating. Oh, I don't want to sell, but if I sell, my property taxes are going to go way up. And the answer is no, they're not. Don't let that be a barrier to selling. They are not going to go up when you buy another house. Okay, so that's a goodness. Pearly going back after the 15-day pay or quit. Normally, pre-COVID, if someone's not paying the rent, you give them a 3-day notice to pay or quit, right? Right now in residential property, until at least the end of September, if someone's not paying rent, you don't give them a 3-day pay or quit, you give them a 15-day COVID pay or quit. It's the form on zip form is the PRQ COVID, the PRQ TP for transition period. And when you give them that form, attached to that 15-day pay or quit is this declaration of COVID financial distress. If the tenant fills out that form and says, yes, I swear to God, I can't pay the rent because of COVID, and they return that in 15 days, you can't evict them. They still got to pay 25% of the rent, but you can't evict them if they don't pay the 75. In fact, even if they don't pay the 25, you can't evict them until October. If they pay the 25 and don't pay the 75, you need to apply for rental assistance to get that money. And the money is there, I'm telling you. If their income is less than 80%, right, then you are not going to be able to even sue them for the money. I mean, you're not going to be able to evict them in October. You're just going to be able to sue them for the money. Joan, the form PRQ, pay, rent, or quit. PRQ TP for transition period. If you just look on Zip form, on the eviction forms, you can't miss it. It's a 15-day PRQ, okay? Hopefully, one of these days, we're going to be able to go back to the old 3-day notice to pay rent or quit, but we can't do it right now, okay? Until at least the end of September. All right. Let's see, is there anything else you should know about? You know, the only other thing I want to mention is, I don't know about you, but we see a lot of buyers, they're getting very creative in their offers. They say things like, my offer is 10% over the appraised value, 10,000 over appraised value, or my property is, my offer is 5,000 more than the next best offer. Or they say things, no, I'm making a non-contingent offers. What we found is a lot of buyers think they understand what they're doing, but they really don't. They don't understand what they're really saying when they make an offer 5,000 more than the next best offer. Or they don't know, or they know the appraisal's probably not going to be as high as the price, so they want to make my offer more than the appraisal, but they don't make sure that they draft it properly. Like someone will say, my offer is, this happened yesterday. Someone said, my offer is 10,000 more than the appraised value. They were assuming it wasn't going to appraise at the purchase price, and then it did appraise at the purchase price. Now they got to pay 10,000 more than the purchase price. They didn't understand that. What I'm really saying is, if you have a buyer who wants to get creative with their offers, you might want to call the legal hotline to make sure it's drafted properly, or better yet, have the buyer get their own lawyer to draft it. That's even better. But anyway, just be careful about buyers writing creative offers, because they may not be drafting them the way they think they're trying to do it. Or if you're the listing agent and you get one of these offers and you want to make sure that you understand what it means, you can talk to a lawyer like the hotline. Gene and Olga, what if they have a COVID reason, but they're still receiving unemployment? Well, if they still say on the declaration, under penalty of perjury, that they can't pay their rent, you're right. If they're getting more money in unemployment than they were getting with their job, you would think it'd be hard to say, I have a hardship here. But it's really up to the buyer. If they sign that form under penalty of perjury, you can't really question the truth of what they're saying, right? I think that's what you're asking. You got to take the buyer, the tenant, you got to take their word for it. If they sign that declaration, they're swearing under penalty of perjury that they really have a financial reason why that's related to COVID that's causing them to not be able to pay the rent. So if they say that, then that's what they're saying, right? Okay. Let's see, anything else? I think that's about it, guys.
Gov, I do have a question for
Yes.
you. So you've talked a little bit about the C.A.R. legal hotline. Maybe you could take a minute and talk a little bit about what the legal hotline is and maybe what it's not. And I'm saying that or asking that because every so often I'll have a member call me, they have a legal issue, they call into the hotline, they end up calling me back later and they get upset because the attorney they spoke to with C.A.R. is not going to represent them in a lawsuit. And of course, that's not what you do. So it's a great service to all realtors in California. Can you take maybe a minute and kind of set it up so they have a good understanding of what it does?
Yeah, so this legal hotline, and I'll put the phone number in the chat, by the way. You can call as many times as you want, and we're going to answer your question. Now, what we're not going to do is, as Mark said, is represent you in court. We're not going to call the other client on your behalf. We're not going to write a nasty letter on your behalf. Although we do have a library of sample letters that we can send you, that you can use them to write it if the other side's not doing what they promised to do. But basically, we're just going to give you advice. We're going to talk to you. And I know a lot of times you're asking on behalf of your client, and we're going to be very careful. Don't be the one actually giving the legal advice to your client, but we can tell you what to tell them. But no, we don't represent you by going to court or anything like that. If you actually need a lawyer to go to court, we'll recommend a lawyer for you. Or if you need a lawyer to draft some 3-page addendum or something, we'll recommend someone, but we're not going to do that. But we're definitely going to answer your questions. And all the 250 forms on zip form, we know them like the back of our hand. We'll explain them to you, all the laws I talk, all this COVID stuff, all this eviction stuff. We'll walk you through it. We'll tell you what form to use. We just don't represent you in the sense of writing a demand letter for you or going to court or anything like that. But it's a good service. It really is. Doug, please address, what about lenders? What about if the problem is a lender? Unfortunately, there's not a whole lot you can do. If a lender is not performing on time, I mean, that's, the lender is not doing a good job for the buyer may want to get a new lender or something, but the lender's doesn't get in trouble just because they take too long. Now, if they say something wrong, if that actually they issue some pre-qualification or pre-approval and they don't stand behind it, if that's what you're asking, that would be a different problem. And then you could, basically what we would say is when you have a lender who's not doing the right thing, you need to file a complaint with whoever regulates that lender. And then it's going to depend on what type of lender it is. Is it a state lender, a federal lender? Are they doing FHA? Are they doing VA? So if you tell us in the given situation who the lender is, we could probably tell you who to complain to. But other than that, there's not a whole lot you can do about lenders that aren't performing the way they're supposed to. Claudia, TDS and SPQ required for a short sale. Yes. The key thing is if you're selling residential 1 to 4, and it's not a probate sale, it's not an REO sale, it's not a bankruptcy sale, and it's not a sale by a trust, the TDS and the SPQ are required. So they are required in short sales because that's not one of the exemptions, okay? Are you actually starting to see short sales again? I wonder about that. But yeah, well, everything goes around, comes around. We'll start seeing everything that we've seen in the past eventually. But yeah, any more questions? I can hang out as long as you want me to. By the way, are there any other new forms? Well, there's no other forms came out now, but of course, end of December, there's going to be a big new form. It's the purchase contract's going to change. So I think you should all take a class. Wow, Doug, 2 short sales in 30 days. I recommend strongly you take the 4-hour class on the new purchase contract sometime this fall. I forget, Mark, if your association is doing one.
We haven't signed up for it, but the access is available to all the membership, so they can all participate. It's available. Yeah.
So in other words, we're gonna do a lot of classes. I'm gonna do a lot of them myself. We're starting in like late August. I'm just giving you a heads up that it's probably a good idea to take this class because there's really going to be a lot of changes in the purchase contract. And not only is the class good, but you're going to get this nice how-to guide that you can keep, a book you can always refer back to that explains every single line of the purchase contract. Plus someone like me is going to walk you through it also. There are a lot of changes. They're good changes. In my opinion, every change in there is good, because basically over the years, we can see what issues come up that aren't really resolved by the purchase contract, and now they would be. And the way to go to find out, Vicky, is, I'll put it on the website. It's store.car.org, and you can do it. That's where to schedule a class. Offices can schedule a class. Anyone can schedule a class, or anyone can just sign on to a class. I mean, it's not restricted. There's some local associations they're not allowed to do this anymore, but when it first started out, they allowed some local associations to sign up to do classes just for that association. And there are about 10 of those. That's why I asked, but they're not allowing that anymore. I mean, you can get a block of people for an association or an office, but you can't really limit it to the people in that office or that association at this point. But there's plenty of classes. Plus, we're going to have free weekly webinars starting in October, which you'll be able to go on to do that also. So we're going to have a lot of available education out there. Plus, as I said, if you take the class, there's this nice long book that you can keep that explains every single clause. So check that out. It's worth taking, I think. And I think you're going to be happy with the changes because they're all good. Of
Yeah.
course,
Gov, I believe, is that a $75 class?
Yes.
Yes. Okay.
$75. I know it's a pain. I wish it were free. It's not my call. But in all honesty, it's worth the money, because not only is it a good class, you're going to get a book that you can keep forever. You can refer to it anytime you want about every paragraph of the form. Okay. And obviously you're going to call the hotline and we'll be available. It's going to be longer than the current form because there's some things in the form that used to be on a separate form that have been incorporated into the contract, which is good. Plus, it just has more stuff that's going to make things go more smoothly. Is the book an ebook? Yes. I don't think it's a hard. I'm not even sure about that, Joan, whether you can actually get a hard copy. You probably print it out and bind it or something. It's probably worth it to do that. But yes. Now you say August 16th. I thought the first class was August 17th, but maybe I'm wrong. Okay. Maybe there's a class I'm not aware of. Are you sure it's the C.A.R. putting on this class? Because I'm sure other people are going to put on the class too. 19th. That's probably more likely. Okay, maybe Neil's doing it on the 16th. Great. And Neil is a great person to do this class because he's the main person who wrote the form. The three of us doing it C.A.R. Neil, me, and someone named Jana Gardner, all very good. Doug, yes, there's going to be a class at the meetings, but it's going to be virtual. It's still going to be virtual. By the way, if any of you guys are thinking about going in Anaheim to the C.A.R. meetings or the expo is going to be virtual. At this point, the meetings are going to be live. But you know, with this Delta thing going on, I'm not counting on anything. I'm planning on being there myself, but we'll see. But as I said, but to answer your question, Doug, the class on the contract at the meetings is going to be virtual. At this point, there are no live contract classes scheduled for this year. But I'm sure next, the form's going to take effect end of December. I'm sure a lot of people are going to say, hey, there's a new form. I want to take a class. So I'm sure we'll be doing classes in January and February. And those might be live. Who knows? I hope so. Yes, Vicky, definitely 4 hours of credit. There's a test. Melinda, yes, the 19th is a good class. That's a good one to go to. By the way, so there's going to be a test. but everyone's going to pass the test because it's like open book, right? You can cheat all you want. Don't worry about the test.
My favorite test.
Yeah, open book cheat. So anyway, it's fine. But anyway, yes, there'll be a test. You have like a day after the class to take the test or whatever. But anyway, yes, sign up for the class, check out the webinars, get the book. Maybe you don't even want to take the class. You just want to buy the book. You can do that too. But the book comes free with the class. And I think there is a sample, Gene and Olga, you can't wait till August, right? You can't wait for 2 weeks. You want to see it now. I'm pretty sure it's somewhere on the website. I'm not exactly sure. Feel free to check it. Yeah, I'm sorry, I don't honestly know, but I'm pretty sure it is available to look at. If you can't wait till August 19th or 17th or whatever. I don't know if the book's available yet. It might be. I'm pretty sure there's a sample form. Yes. And you know what this means, of course. All the forms that are connected to the purchase contract are also being tweaked. Everything from the contingency removal form, right? All the forms that reference the purchase contract are all the forms that the purchase contract references, like you know, everything is being tweaked. So it all works together. All the references to the paragraphs on the other forms you use connected to, you know, a normal transaction, what are they, you know, notice the buyer to perform, all these things that you use are also being tweaked. I think pretty much all those forms are ready too. They're all going to be ready. They're not going to be released until December. They'll be ready to look at, they'll be in the book. And then of course, as you know, there's 7 other purchase contracts. There's the income property purchase contract, the commercial purchase contract, the vacant land purchase contract, the condo conversion purchase contract, and all of those are being changed also. So they're all the same, you know what I mean? All of the purchase contracts normally use the residential RPA, but if any of you do probate, you know, there's no more probate contract, it's just a probate addendum. But new construction, any type of purchase contract you're going to use, they're all going to be changed by December, as are all of the ancillary forms that go along with the purchase contract. So everything's going to be totally consistent. There's not going to be really any new concepts. Everything you're familiar with now is still going to be there, but it's going to be a little bit expanded with more explanations and more, just more good stuff. And the only sort of format change that you'll notice is all of the places where you have to make a decision, like who pays or how much, or what's the time deadline, those are all going to be in one paragraph, paragraph 3. In other words, right now it's spread out through the whole contract. Like on this paragraph 6, I check a box, paragraph 9, I check a box, or I got to write buyer or seller is responsible in paragraph 7. All of the places where you have to make a decision as to what's the deadline, who's going to pay and who's responsible, those are all going to be grouped together in one paragraph. So that's good. Hopefully that means everyone, some people I know are going to say, I'll just read that paragraph. I'm not going to read the rest of the contract. Well, you need to read the rest of the contract to understand it. But anyway, that'll be I know I'm enticing you now. You're curious now. But I'm also worried that some people are going to start learning the new form and then get confused, because between now and the end of the year, you're still using the old form. So you're going to have to sort of keep track of both of them. That's why it's good you have this book to reference. Okay. Anyway.
And Gov, I just put a draft in the comments.
Thanks, Vicky. Vicky is so helpful. So if I were you, I wouldn't look at it too hard. I just don't want you to confuse yourself about the, maybe start looking at it right before you take the class or after the class. Because remember, this is not available until December. All your transactions you use the rest of the year, you're going to be using the old form. the current form. Okay, but yeah, if you want to look at it, there it is. Thanks, Vicki.
Gov, I want to thank you. What I'm going to do is this is being recorded today. We'll have it posted on IVAR's website tomorrow. In addition to that, I'll also include on the link the Q&A defensible space report that came out from the attorneys and you folks. So anybody has any questions on that, we'll include that. And I'll probably link some additional information regarding the updated RPA form. So everybody that's participating today will get some additional information. So we'll be pushing that out to everybody in the next couple of days.
All right.
All right. And with that, I just want to thank you, Gov. As always, you are a fountain of knowledge. Great job. Hope to see you in October at Anaheim at the conference if it moves forward. We're actually meeting in live
I sure
at
hope
that
so.
time.
All right.
But until that time, thank you so much. And hope to see everybody soon. Take care.
Bye, everybody.